Module 2, Administration of an Assisted Living Facility. The purpose of this module is to teach trainees the administrative aspects of operating an ALF, including fire safety and emergency planning. In this module, we'll demonstrate knowledge of the minimum requirements for an ALF administrator, how to maintain administrator credentials, and an administrator's responsibilities. Understand the need for the facility's physical stability and action required in case of physical instability. Demonstrate an understanding of the guidelines for handling residents' finances and property. Demonstrate knowledge of the minimum staffing requirements and how to calculate them. In Module 2, we'll also demonstrate knowledge of background screening requirements. Identify the need for mandatory in-service training for various staff members, including but not limited to infectious diseases, residues, HIV and AIDS, CPR and first aid, and how to document training. Define the term adverse incident and demonstrate knowledge of how to report it. Demonstrate knowledge of the physical plant standards, including but not limited to building code compliance, minimum requirements for space, furnishings, and temperature. Module 2 also demonstrates knowledge of the requirements regarding compliance with local regulatory agencies, fire and elopement standards and drills, and evacuation capability. Of comprehensive emergency management plan, disaster preparedness, where to submit the plan, and how often to review it. Demonstrate understanding of the uniform fire safety standards for ALFs as well. Minimum requirements for an ALF administrator, how to maintain administrator credentials, and administrator's responsibilities. Individual at least 21 years of age who is responsible for the operation and maintenance of an assisted facility is an administrator. Every facility must be under the supervision of an administrator who is responsible for the operation and maintenance of the facility, including the management of all staff and the provision and appropriate care to all residents. An administrator must complete core training. It's a 26-hour course. And you must pass core competency tests with at least a 75%. It's 100 questions. It's multiple choice. You just need 75 right out of 100 to be qualified as an administrator. And then you need 12 hours of continuing education every 2 years. To become an administrator, you must be at least 21 years of age. If employed on or after October 30th, 1995, have at a minimum a high school diploma or GED. Be in compliance with level 2 background screening. Complete the core training and core competency tests. Requirements: no later than 90 days after becoming employed as a facility administrator. Administrators who attended core training prior to July 1st, 1997 are not required to take the competency test unless specified elsewhere in this rule. Satisfy the continuing education requirements. Administrators who are not in compliance with these requirements must retake the core training and core competency test requirements in effect on the date the non-compliance is discovered by the agency or the department. In circumstances such as death of the facility administrator, the agency may permit an individual who otherwise has not satisfied the training requirements to temporarily serve as the facility administrator for a period not to exceed 90 days. During the 90-day period, the individual temporarily serving as the facility administrator must complete the core training and core competency test requirements and complete all additional training requirements if the facility maintains licensure extended congregate care or a limited mental health facility. Administrators may supervise a maximum of either 3 assisted living facilities or a group of facilities on a single campus providing housing and health care. Administrators who supervise more than one facility must appoint in writing a separate manager for each facility. However, an administrator supervising a maximum of 3 assisted living facilities, each licensed for 16 or fewer beds, and all within a 15-mile radius of each other, is only required to appoint 2 managers to assist in the operation and maintenance of those facilities. An individual serving as a manager must satisfy the same qualifications, background screening, core training, and competency test requirements, and continuing education requirements as an administrator. Managers who attended the core training program prior to April 20th, 1998 are not required to take the competency test unless specified elsewhere in this rule. In addition, a manager may not serve as a manager of more than a single facility and may not simultaneously serve as an administrator of any other facility. Facility owners must notify the agency central office within 10 days of change in a facility administrator on the notification of change of administrator form. This is ACA Form 3180-1006, June 2016, which is incorporated by reference and available online at this address provided. The administrator or owner of a facility shall maintain liability insurance coverage that is in force at all times. On the renewal date of the facility's policy, or whenever a facility changes policies, the facility must file documentation of continued coverage with the agency central office. Such documentation must be issued by the insurance company and must include the name and street address, a reference that the facility is an assisted living facility, the facility's license capacity, and the coverage. Insurance against legal liability for the death, injury, or disability of any being or the damage to property, with provision for medical, hospital, and surgical benefits to the injured persons, irrespective of the legal liability of the insured when issued as a part of a liability insurance contract. Understanding the need for the facility's physical stability and actions required in case of physical instability. The administrator or owner of a facility shall maintain accurate business records that identify, summarize, and classify funds received and expenses dispersed, and shall use accounting procedures and a recognized accounting system. The facility must be administered on a sound financial basis in order to ensure adequate resources to meet residents' needs. Each facility must report to the agency any adverse court action concerning the facility's financial viability within 7 days after its occurrence. The agency shall have the access to books, records, and any other financial documents maintained by the facility to the extent necessary to determine the facility's financial stability. A facility, upon mutual consent with the resident, shall provide for the safekeeping in the facility of personal effects not in excess of $500 and funds of the resident not in excess of $500 cash, and shall keep complete and accurate records of all such funds and personal effects received. If a resident is absent from a facility for 24 hours or more, the facility may provide for the safekeeping of the resident's personal effects in excess of $500. Any personal funds available to facility residents may be used by residents as they choose to obtain clothing, personal items, leisure activities, and other supplies and services for their personal use. A facility may not demand, require, or contract for payment of all or any part of the personal funds in satisfaction of the facility rate for supplies and services beyond the amount agreed to in writing, and may not levy any additional charge to the individual or the account for any supplies or services that the facility has agreed by contract to provide as part of the standard monthly rate. Any service or supplies provided by the facility which are charged separately to the individual or the account may be provided only with the specific written consent of the individual, who shall be furnished in advance of the provision of the services or supplies with an itemized written statement to be attached to the contract setting forth the charges for the services or supplies. Funds or other property received by the facility belonging to or due to a resident, including personal funds, must be held as trust funds and expended for the resident's account. Resident funds or property may be held in one bank account if a separate written account for each resident is maintained. A separate bank account is required for facility funds. Commingling resident funds with facility funds is prohibited. Written accounting procedures for residents' trust funds must include income and expense records of the trust fund, including the source and disposition of the funds. A facility or an owner, administrator, employee, or representative thereof may not act as the guardian, trustee, or conservator for any resident of the assisted living facility or any of such resident's property. An owner, administrator, or staff member or representative thereof may not act as competent residence payee for Social Security, veterans, or railroad benefits without the consent of the resident. Any facility whose owner, administrator, or staff or representative thereof serves as representative payee for any resident of the facility shall file a surety bond with the agency in the amount equal to twice the average monthly aggregate income or personal funds due to residents or expendable for their account, which are received by a facility. Any facility whose owner, administrator, or staff or representative thereof is granted power of attorney for any resident of the facility shall file a surety bond with the agency for each resident for whom such power of attorney is granted. The surety bond shall be in an amount equal to twice the average monthly income of the resident plus the value of the resident's property under the control of the attorney in fact. The bond shall be executed by the facility as principal and a licensed surety company. The bond shall be conditioned upon the faithful compliance of the facility with the section and shall run to the agency for the benefit of any resident who suffers a financial loss as a result of the misuse or misappropriation by a facility of funds held pursuant to this subsection. Any surety company that cancels or does not renew the bond of the license shall notify the agency in writing, not less than 30 days in advance of such action, given the reason for the cancellation or non-renewal. Any facility owner, administrator, or staff or representative thereof who is granted power of attorney for any resident of the facility shall, on a monthly basis, be required to provide the resident a written statement of any transaction made on behalf of the resident pursuant to this subsection, and a copy of the statement given to the resident shall be retained in each resident's file and available for the agency inspection. For entities that own more than one facility in the state, one surety bond may be purchased to cover the needs of all residents served by the entities. The following additional bonding requirements apply to facilities serving residents receiving OSS. If serving as representative payee resident receiving OSS, the minimum bond proceed must equal twice the value of the resident's monthly income, which must include the supplemental security income or Social Security disability income plus the OSS payments, including the personal needs allowance. If holding a power of attorney for a resident receiving OSS, the minimum bond proceeds must equal twice the value of the resident's monthly aggregate income, which must include any supplemental security income or Social Security disability income, the OSS payments, including the personal allowance, plus the value of any property belonging to a resident held at the facility. Upon the annual issuance of a new bond of continuation bond, the facility must file a copy of the bond with the agency's central office. Minimum staffing standards. Staffing standards. All staff must comply with the training requirements, including the administrator. Notice of change of administrator. If during the period for which a license is issued, the owner changes administrators, the owner must notify the agency of the change within 10 days and provide documentation within 90 days that the new administrator meets educational requirements and has completed the applicable core educational requirements. A facility may not be operated for more than 120 consecutive days without an administrator who has completed the core educational requirements. Within 30 days after being employed, newly hired staff must submit a written statement from a healthcare provider documenting that the individual does not have any signs or symptoms of communicable disease. The examination performed by the healthcare provider must have been conducted no earlier than 6 months before submission of the statement. Evidence of a negative tuberculosis examination must be documented on an annual basis. Documentation provided by health or a licensed healthcare provider certifying that there is a shortage of tuberculosis testing material satisfies the annual tuberculosis examination requirement. An individual with a positive TB test must submit a healthcare provider statement that the individual does not constitute a risk of communicating tuberculosis, also known as TB. Newly hired staff does not include an employee transferring without a break in service from one facility to another when the facility is under the same management or ownership. If any staff member has or is suspected of having a communicable disease, such individual must be immediately removed from duties until a written statement is submitted from a healthcare provider indicating the individual does not constitute a risk of transmitting a communicable disease. Staff must be qualified to perform their assigned duties consistent with their level of education, training, preparation, and experience. Staff providing services requiring licensing or certification must be appropriately licensed or certified. All staff must exercise their responsibilities consistent with their qualifications. To observe residents, to document observations on the appropriate residence record, and to report the observations to the resident's healthcare provider. An assisted living facility contracting to provide services to residents must ensure that individuals providing services are qualified to perform their assigned duties. The contract between the facility and the staffing agency or contractor must specifically describe the services the staffing agency or contractor will provide to residents. For facilities with a licensed capacity of 17 or more residents, the facility must develop a written job description for each staff position and provide a copy of the job description to each staff member, and maintain timesheets for all staff. Level 2 background screening must be conducted for staff, including staff contracted by the facility to provide services to residents. For every 20 total combined residents, daycare participants, and respite care residents over 95, add 42 staff hours per week. Supervision by an administrator who has a minimum of 2 years of managerial, nursing, social work, therapeutic recreation, or counseling experience in a residential, long term care, or acute care setting, or agency serving elderly or disabled persons. If an administrator appoints a manager as the supervisor of an extended congregate care facility, both the administrator and manager must satisfy the requirements subsection 59A-36.010 in parentheses 1, Florida Administration Code. Staffing requirements for ECC. A bachelorette degree may be substituted for 1 year required experience. A nursing home administrator license under Chapter 468 Florida statutes is qualified under this paragraph. Provide staff or contract the services of a nurse who must be available to provide nursing services, participate in the development of a resident service plan, and perform monthly nursing assessments for extended congregate care residents. Provide enough qualified staff to meet the needs of extended congregate care residents in accordance with Rule 59A-36.010 Florida Administration Code and to provide the services established in each resident service plan. Ensure that adequate staff is awake during all hours to meet the scheduled and unscheduled needs of residents. Immediately provide additional or appropriately qualified staff. When the agency determines the service plans are not being followed or that residents' needs are not being met because insufficient staffing in accordance with the staffing standards established in Rule 59A-36.010. Ensure and document the staff receive extended congregate care training as required in Rule 59A-36.011 Florida Administration Code. Independent living residents who occupy beds included within the licensed capacity of an assisted living facility but do not receive personal, limited nursing, or extended congregate care services are not counted as residents for purpose of computing minimum staff hours. At least one staff member who has access to facility and residents' records in case of an emergency must be in the facility at all times when residents are in the facility. Residents serving as paid or volunteer staff may not be left solely in charge of other residents while the facility administrator, manager, or other staff are absent from the facility. In facilities with 17 or more residents, there must be at least one staff member awake at all hours of the day and night. A staff member who has completed courses in first aid and cardiopulmonary resuscitation (CPR) and holds a current valid card documenting completion of such courses must be in the facility at all times. A nurse is considered as having met the course requirements for first aid, and an emergency medical technician or paramedic currently certified is considered as having met the course requirements for both first aid and CPR as well. During periods of temporary absence of the administrator or manager of more than 48 hours when residents are on the premises, A staff member who is at least 21 years of age must be physically present and designated in writing to be in charge of the facility. No staff member shall be in charge of a facility for a consecutive period of 21 days or more, or for a total of 60 days within a calendar year, without being an administrator or a manager. Staff whose duties are exclusively building or grounds maintenance, clerical, or food preparation do not count towards meeting the minimum staffing requirements. The administrator or manager's time may be counted for the purpose of meeting the required staffing hours, provided the administrator or manager is actively involved in the day-to-day operation of the facility, including making decisions and providing supervision for all aspects of resident care, and is listed on the facility staffing schedule. Only on-the-job staff may be counted in meeting the minimum staffing hours. Vacant positions or absent staff may not be counted. All facilities, including those composed of apartments, must have enough qualified staff to provide residents supervision and to provide or arrange for resident services in accordance with the resident's scheduled and unscheduled service needs, residents' contracts, and residents' care standards. The facility must maintain a written work schedule that reflects its 24-hour staffing pattern given time period. Upon request, the facility must make the daily work schedules of direct care staff available to residents or their representatives. The facility must provide staff immediately when the agency determines that the staffing requirements are not met. The facility must immediately increase staff above the minimum levels if the agency determines that adequate supervision and care are not being provided to residents, resident care standards are not being met, or the facility is failing to meet the terms of resident contracts. The agency will consult with the facility administrator and residents regarding any determination that additional staff is required. Based on the recommendations of the local fire safety authority, the agency may require additional staff when the facility fails to meet the fire safety standards, until such time as the local fire safety authority informs the agency that fire safety requirements are being met. When additional staff is required above the minimum, the agency will require a submission of a corrective action plan within the time specified in the notification indicating how the increased staffing is to be achieved to meet resident service needs. The plan will be reviewed by the agency to determine if it sufficiently increases the staffing levels to meet resident needs. When the facility can demonstrate to the agency that residents' needs are being met, or the resident needs can be met without increased staffing, the agency may modify staffing requirements for the facility, and the facility will no longer be required to maintain a plan with the agency. Facilities that are co-located with a nursing home may use shared staffing, provided that staff hours are only counted once for the purpose of meeting either assisted living facility or nursing home minimum staffing ratios. Facilities holding a limited mental health, extended congregate care, or limited nursing service license must also comply with the staffing requirements. Knowledge of background screening requirements. Level 2 background screening must be conducted for staff, including staff contracted by the facility to provide services to residents. Level 1 background for staff whose duties are exclusively building or grounds, maintenance, clerical, or food preparation do not count towards meeting the minimum staffing hours requirements. Applicants applying for a position that shall be in direct contact with the resident shall need at a minimum a successful passing level 2 background screening before being offered a position of hire. Identify the need for mandatory in-service training for various staff members, including but not limited to infectious disease, residents' rights and abuse, HIV and AIDS, CPR and first aid, and how to document training. Administrators and other assisted living facility staff must meet minimum training and education requirements. Training and education is intended to assist facilities to appropriately respond to the needs of a resident, to maintain resident care and facility standards, and to meet licensure requirements. A facility administrator must complete the required core training, including the competency test, within 90 days after the date of employment as an administrator. 12-year education every 2 years. An individual serving as a manager must satisfy the same qualifications, background screening, core training, and competency test requirements, and continuing education requirements as an administrator. Complete all additional training requirements if the facility maintains licensure as an extended congregate care or limited mental health facility. The administrator, managers, and staff who have direct contact with mental health residents in a licensed limited mental health facility must receive the following training. A minimum of 6 hours of specialized training in working with individuals with mental health diagnosis. The training must be provided by or approved by the Department of Children and Families and must be taken within 6 months of the facilities receiving a limited mental health license or within 6 months of employment in a limited mental health facility. Training received may count once for 6 of the 12 hours of continuing education required for administrators and managers. A minimum of 3 hours of continuing education, which may be provided by the ALF administrator, online distance learning, biannually thereafter in subject dealing with one or more of the following topics: mental health diagnosis, mental health treatment, mental health needs, services, behaviors, and appropriate interventions, residents' progress in achieving treatment goals, how to recognize changes in the resident status or condition that may affect other services received or may require intervention, crisis services, and the Baker Act procedures. For administrators and managers, the continuing education requirement under the subsection will satisfy 3 of the 12 hours of continuing education required biannually. Administrators, managers, and direct care staff affected by the continuing education requirements under the subsection shall have up to 6 months after the effective date of this rule to meet the training requirement. Staff, staff must be qualified to perform their assigned duties consistent with their level of education, training, preparation, and experience. Staff providing services requiring licensing or certification must be appropriately licensed or certified. The agency, in conjunction with providers, shall develop core training requirements for administrators consisting of core training learning objectives, a competency test, and a minimum required score to indicate successful passage of the core competency test. The required core competency test must cover at least the following topics: state law and rules relating to assisted living facilities, residents' rights, and identifying and reporting abuse, neglect, and exploitation, special needs of elderly persons, persons with mental illness, and persons with developmental disabilities, and how to meet those needs. Nutrition and food service, including acceptable sanitation practices for preparing, storing, and serving food, medication management, record keeping, and proper techniques for assisting residents with self administered medication, fire safety requirements, including fire evacuation, drills, procedures, and other emergency procedures, care of persons with Alzheimer's disease and related disorders. The assisted living facility core training requirements established by the department shall consist of a minimum of 26 hours of training plus a competency test. Administrators and managers must successfully complete the assisted living facility core training requirements within 3 months from the date of becoming a facility administrator or manager. Successful completion of the core training requirements includes passing the competency test. The minimum passing score for the competency test is 75%. Administrators as nursing home administrators are exempt from this requirement. Administrators and managers shall participate in 12 hours of continuing education and topics related to assisted living every 2 years. A newly hired administrator or manager who has successfully completed the assisted living facility core training and continuing education requirements shall not be required to retake the core training. An administrator or manager who has successfully completed the core training but has not maintained the continuing education requirements will be considered a new administrator or a manager for the purpose of the core training requirements and must retake the assisted living facility core training and retake and pass the competency test. The fees for the competency test shall not exceed $200. The payment for the competency test fee shall be remitted to the entity administering the test. A new fee is due each time the test is taken. Identify the need for mandatory in-service training for various staff members, including but not limited to infectious disease, residents' rights and abuse, HIV/AIDS, CPR and first aid, and how to document training. Each new assisted living facility employee who has not previously completed core training must attend a pre-service orientation provided by the facility before interacting with residents. The pre-service orientation must be at least 2 hours in duration and cover topics that help the employee provide responsible care and respond to the needs of the facility residents. Upon completion, the employee and the administrator of the facility must sign a statement that the employee completed the required pre-service orientation. The facility must keep the signed statement in the employee's personal record. Facility staff shall participate in in-service training relevant to their job duties as specified by agency rule. Topics covered during the pre-service orientation are not required to be repeated during in-service training. A single certificate of completion that covers all required in-service training topics may be issued to a participating staff member if the training is provided in a single training course. Facilities must provide a pre-service orientation of at least 2 hours to all new assisted living facility employees who have not previously completed core training. New staff must complete the pre-service orientation prior to interacting with residents. Once complete, the employee and the facility administrator must sign a statement that the employee completed the pre-service orientation, which must be kept in the employee's personal records. In addition to topics that may be chosen by the facility administrator, the pre-service orientation must cover residents' rights and the facility's license type and services offered by the facility. Staff in-service training. Facility administrators or managers shall provide or arrange in-service training to facility staff. Facility administrators or managers shall provide or arrange the following in-service training to facility staff. Facilities must provide in-services in a manner that reduces the risk of transmission of infectious diseases. The facility must implement a hand hygiene program before and after the provision of personal services to a resident whenever there is an expectation of possible exposure to infectious material or body fluids. Hand hygiene may include the use of alcohol-based rubs, antiseptic hand wash, or hand washing with soap and water. Standard precautions must be used when there is an anticipated exposure to transmissible infectious agents in blood, body fluids, secretions, excretions, non-intact skin, and mucous membranes during the provision of personal services. Standard precautions include hand hygiene and, dependent upon the exposure, use of gloves, gown, mask protection, or a face shield. The facility must clean and disinfect reusable medical equipment and communal assistive devices that have been designed for use by multiple residents before and after each use according to the manufacturer's recommendations. Staff who provide direct care to residents other than nurses, certified nursing assistants, or home health aides must receive a minimum of 1 hour in-service training in infection control, universal precautions, facility sanitation procedures, And before providing personal care to residents, the facility must use its infection control policies and procedures when offering this training. Documentation of compliance with the staff training requirements relating to bloodborne pathogens may be used to meet this requirement. Staff who provide direct care to residents must receive a minimum of 1 hour in-service training within 30 days of employment that covers the following subjects: reporting adverse incidents, facility emergency procedures, including chain of command, and staff roles relating to emergency evacuation. Staff who provide direct care to residents who have not taken the core training program shall receive a minimum of 1 hour in-service training within 30 days of employment that covers the following subjects: residents' rights in an assisted living facility. Staff who provide care to other than nurses, CNAs, and home health aides must receive hours of in-service training within 30 days of employment that covers the following subjects: resident behaviors and needs, providing assistance with activity daily living. Staff who prepare or serve food who have not taken the assisted living facility core training must receive a minimum of 1 hour in service training within days of employment in a safe food handling practices. All facilities service training regarding the facility's resident elopement response policies and procedures within 30 days of employment. All facility staff shall be provided with a copy of the facility's resident elopement response policies and procedures. All facility staff shall demonstrate an understanding and competency in the implementation of the elopement response policies and procedures. A copy of the resident's Bill of Rights or a summary provided by the Long-Term Care Bondsman's Program must be posted in full view in a freely accessible resident included in the admission package provided. The facility must have a written grievance procedure for receiving and responding to a resident's complaints, and a written procedure to allow residents to recommend changes to a facility policy and procedures. The facility must be able to demonstrate that such procedure is implemented upon receipt of a complaint. The telephone number for lodging complaints against a facility or facility staff must be posted in full view in a common area accessible to all residents. The telephone numbers are provided below. The facility must have a written statement of its house rules and procedures that must be included in the admission package provided. The rules and procedures must, at a minimum, address the facility's policies regarding resident responsibilities, alcohol and tobacco use, medication storage, resident elopement, reporting resident abuse, neglect, and exploitation, administrative and housekeeping schedules and requirements, infection control, sanitation, and standard precautions, the requirements for coordinating the delivery of services to residents by third-party providers, assistive devices, and physical restraints. Residents may not be required to perform any work in the facility without compensation. Residents may be required to clean their own sleeping areas or apartments if the facility rules and the facility contract include such a requirement. If a resident is employed by the facility, the resident must be compensated in compliance with state and federal wages laws. The facility might require convenient access to a telephone to facilitate the residents' rights to unrestricted private communication pursuant to Section 429.28. The facility must
Allow unidentified telephone calls to residents. For facilities with a license capacity of 17 or more residents in which residents do not have private telephones, there must be at minimum a readily accessible telephone on each floor of each building where residents reside. HIV or AIDS. All facility employees must complete a one-time education course on HIV and AIDS. New facility staff must obtain the training within 30 days of employment. Documentation of compliance must be maintained with employee records. That may be a question on the test. First aid and CPR, resuscitation. A staff member who has completed courses in first aid and CPR and holds a currently valid card documenting completion of such courses must be in the facility at all times. Documentation that the staff member possesses current CPR certification that requires the student to demonstrate in person that he or she is able to perform CPR and which is issued by an instructor or training provider that is approved to provide CPR training by the American Red Cross, the American Heart Association, the National Safety Council, or an organization whose training is accredited by the Commission on Accreditation for Pre-Hospital Continuing Education satisfies this requirement. Find the term accident and demonstrate knowledge of how to report it. Every facility, as part of its administrative functions, voluntarily establish a risk management and quality assurance program, the purpose of which is to assess residents' care practices, facility incident reports, deficiencies cited by the agency, adverse incident reports, and resident grievances, and develop plans of actions to correct and respond quickly to identify the differences. Every facility is required to maintain adverse incident reports for purposes of this section. The term adverse incident means an event over which facility personnel could control rather than as a result of the resident's condition and was in 1. Death, 2. Brain or spinal damage, 3. Permanent disfigurement, 4. Fracture or dislocation of bones or joints, 5. Any condition that required medical attention to which the resident has not given his or her consent, including failure to honor advance directives. Any condition that requires the transfer of the resident from the facility to a unit providing more acute care due to the incident rather than the resident's condition before the incident. An event that is reported to law enforcement or its personnel for investigation, or resident elopement if the elopement places the resident at risk or harm or injury. Within 1 business day after the occurrence of an adverse incident throughout the agency's online portal, or if the portal is offline, by electronic a preliminary report to the agency on all adverse incidents. The report must include information regarding the identity of the affected resident, the type of adverse incident, and the status of the facility's investigation of the incident. Licensed facilities shall provide within 15 days throughout the agent's online portal, or if the portal is offline, by electronic mail, a full report to the agency on all adverse incidents specified in this section. The report must include the results of the facility's investigation into the adverse incident. Abuse, neglect, or exploitation must be reported to the Department of Children and Families. The information reported to the agency which relates to a person's license shall be reviewed by the agency. The agency shall determine whether any of the incidents potentially involved conduct by a healthcare professional who is subject to disciplinary action, in which case the provisions apply. The agency may investigate as it deems appropriate any such incident and prescribe measures that must or may be taken in response to the incident. The agency shall review each incident and determine whether it potentially involved conduct by a healthcare professional who is subject to disciplinary action, in which case the provisions apply. If the agency, through the receipt of the adverse incident reports prescribed in this part or through any investigation, has reasonable belief that conduct by a staff member or employee of a licensed facility is ground for disciplinary action by the appropriate board, the agency should report this fact to such regulatory board. The adverse incident reports and preliminary adverse incident reports required are confidential as provided by law and are not discoverable or admissible in any civil or administrative action, except in disciplinary proceedings by the agency or appropriate regulatory board. Knowledge of the physical plant standards, including but not limited to building code compliance, minimum requirements for space, furnishing, and temperature. Newly constructed facilities to be licensed as assisted facilities and existing structures not previously licensed as assisted living facilities to be converted to assisted living facilities, as well as any subsequent additions, modifications, alterations, renovations, or refurbishing of such facilities are required by governmental entities other than of elder affairs to adhere to certain building codes and fire safety standards. Such standards may be found in an assisted living facility must comply with the rule or building code in each at the time of initial licensure, as well as the rule or building code in each in effect at the time of any modifications, alterations, refurbishments, renovations, or reconstruction. Determination of the installation of fire sprinklers in an assisted living facility must comply with the requirements. A facility undergoing change of ownership is considered an existing facility for purposes of this rule. Physical plant, safe living environment, other. All facilities must provide a safe living environment, be maintained free of hazards, and ensure that all existing architectural, mechanical, electrical, and structural systems and appurtenances are maintained in good working order. Residents must be given the option of using their own belongings as space permits. When the facility supplies the furnishing, each resident's bedroom or sleeping area must have at least the following furnishings. 1. A clean, comfortable bed with a mattress no less than 36 inches wide and 72 inches long, with the top surface of the mattress at a comfortable height to ensure easy access by the resident. 2. A closet or wardrobe space for hanging clothes. 3. A dresser, chest, or other furniture
designed for storage of clothing or personal effects. 4. A table or nightstand, bedside lamp or floor lamp, and wastebasket. 5. And a comfortable chair if requested. 6. The facility must maintain master or duplicate keys to resident's bedroom to be used in the event of an emergency. 7. Residents who use portable bedside commodes must be provided with privacy during use. And 8. Facilities must make available linens and personal laundry services for residents who require such services. Linens provided by a facility must be free of tears, stains, and must not be threadbare. Local agencies and elopement standards and drills evacuation capabilities. Local fire safety means the authority having jurisdiction. State covers all jurisdictions within that state. Conduct fire safety inspections. Overlook fire safety reports. Determination of the installation of a fire sprinkler system and or fire alarm system. Local Department of Health. Sanitation, food service assistance, inspections. Elopement standards. Elopement means an occurrence in which a resident leaves a facility without following facility policy and procedures. Residents assessed at risk for elopement. All residents assessed at risk for elopement or with any history of elopement must be identified so staff can be alerted to their needs for support and supervision. All residents must be assessed for risk of elopement by a health care provider or a mental health care provider within 30 calendar days of being admitted to a facility. If the resident has had a health assessment performed prior to admission, this requirement is satisfied. A resident placed in a facility on a temporary emergency basis by the Department of Children and Families is exempt from this requirement for up to 30 days. As part of its resident elopement response policies and procedures, the facility must make, at a minimum, a daily effort to determine that at-risk residents have identification on their persons that includes their name and the facility's name, address, and telephone number. Staff trained must be generally aware of the location of all residents assessed at high risk for elopement at all times. The facility must have a photo identification of at-risk residents on file that is accessible to all facility staff and law enforcement as necessary. The facility's file must contain the resident's photo identification upon admission or upon being assessed at risk for elopement subsequent to admission. The photo identification may be provided by the facility, the resident, or the resident's representative. Facility resident elopement response policies and procedures. The facility must develop detailed written policies and procedures for responding to a resident elopement. At a minimum, the policies and procedures must provide 1. An immediate search of the facility and premises. 2. The identification of staff responsible for implementing each part of the elopement response policies and procedures, including specific duties and responsibilities. 3. The identification of staff responsible for contacting law enforcement, the resident's family, guardian, healthcare surrogate, and case manager if the resident is not located. And 4.
the continued care of all residents within the facility in the event of an elopement. Facility resident elopement drills. The facility must conduct a document resident elopement drill. The components of comprehensive emergency management plan. Disaster preparedness, where to submit the plan, and how often to review it. Each facility must prepare a written comprehensive emergency management plan in accordance with the emergency management criteria for assisted living facilities, dated October 1995, which is incorporated by reference and available at www.floridarules.org. This document is available from the local emergency management agency. Emergency management. The emergency management plan must at minimum address the following: provisions for all hazards, provision for the care of residents remaining in the facility during an emergency, including pre-disaster or emergency preparation, protecting the facility, supplies, emergency power, food and water, staffing, and emergency equipment. Provision for the care of residents who must be evacuated from the facility during an emergency, including identification of such residents and transfer of resident records. Evacuation, transportation, sheltering arrangements, supplies, staffing, emergency equipment, and medications. Provision for the care of additional residents who may be evacuated to the facility during an emergency includes the identification of such residents, staffing, and supplies. Identification of residents with Alzheimer's disease or related disorders and residents with mobility limitations who may need specialized assistance either at the facility or in case of evacuation. Identification of and coordination with the local emergency management agency. Arrangement for post-disaster activities, including responding to family inquiries, obtaining medical intervention for residents, transportation, and reporting to the local emergency management agency the number of residents who have been relocated and the place of relocation, and the identification of staff responsible for implementing each part of the plan. Emergency plan approval. The plan must be submitted for review and approval to the local emergency management agency. If the local emergency management agency requires revisions to the emergency management plan, such revisions must be made and the plan resubmitted to the local office within 30 days of receiving notification that the plan must be revised. A new facility and facilities whose ownership has been transferred must submit an emergency management plan within 30 days after obtaining a license. The facility must review its emergency management plan on an annual basis, yearly basis. Any substantive changes must be submitted to the local emergency agency for review and approval. Changes in the name, address, telephone number, or position of staff listed in the plan are not considered substantive revisions for the purposes of this rule. Changes in the identification of specific staff must be submitted to the local emergency management agency annually as a signed and dated addendum that is not subject to review and approval. The local emergency management agency is the final administrative authority for emergency management plans prepared by assisted living facilities. All staff must be trained in their duties and are responsible for implementing the emergency management plan. If telephone service is not available during an emergency, the facility must request assistance from local law enforcement or emergency management personnel in maintaining communication. The facility must evacuate the premises during or after an emergency if so directed by the local emergency management agency. The facility must report the evacuation to the local Office of Emergency Management or designee and to the agency within 6 hours of the evacuation order. If the evacuation takes more than 6 hours, the facility must report when the evacuation is completed. The facility must not be reoccupied until the area is cleared for re-entry by the local emergency management agency for its designee, and the facility can meet the immediate needs of the residents. A facility with significant structural damage must relocate residents until the facility can be safely reoccupied. The facility is responsible for knowing the location of all residents until the residents have been relocated to another facility. The facility must provide the agency with the name of a contact person who must be available by telephone 24 hours a day, 7 days a week, until the facility is reoccupied. The facility must assist in the relocation of residents and must cooperate with outreach teams established by the Department of Health or Emergency Management Agency to assist in relocation efforts. Residents' needs and preferences must be considered to the extent possible in any relocation decision. People under contract to the facility staff, or volunteers who are licensed may administer medications to residents, take residents' vital signs, change residents' bandages for minor cuts and abrasions, manage individual weekly pill organizers for residents who self-administer medication, give prepackaged enemas ordered by a physician, observe residents, document observations on the appropriate resident's record, report observations to the resident's physician, and contract or allow residents or a resident's representative, designee, surrogate, guardian, or attorney in the fact to contract with a third party, provided residents meet the criteria for appropriate nursing assistants. Certified may take residents' vital signs as directed by a licensed nurse or physician. All staff shall exercise the professional responsibility to observe residents, to document observations on the appropriate resident's record, and to report the observations to the resident's physicians. However, the owner or administrator of the facility shall be responsible for determining that the resident receiving services is appropriate for residents in the facility. In an emergency, licensed personnel may carry out their professional duties until emergency medical personnel assume responsibility for care. In facilities licensed to provide extended congregate care, persons under contract to the facility staff, or volunteers who are licensed, or those persons exempt or certified as nursing assistants, may also perform all duties within the scope of their license or certification as approved by the facility administrator. Fire safety. Fire safety assistance for compliance can be received from your local fire department, authority having jurisdiction, AHJ. You can also contact the state's fire marshal for direction and assistance. (69A-40.028) Standards of the National Fire Protection Association. The Uniform Fire Safety Standards applicable to ALFs in Florida, including other buildings or structures located on the premises of said ALFs, are the standards of the National Fire Protection Association for life safety from fire, as they relate to ALFs. Fire exit drills. Sprinkled. Conduct at least 6 fire drills per year, one every 2 months, with a minimum of 2 drills conducted during the night when residents are sleeping. Facilities that are fully sprinkled and in compliance with other fire safety standards conduct more than one of the 2 required nighttime fire drills between the hours of 11 p.m. and 7 a.m. per year.
Fire exit drills, not sprinkled, shall conduct fire exit drills monthly, and at least 12 fire drills shall have been conducted in the previous year, 4 times per year on each new shifts. ALFs with 8 or fewer residents and a prompt evacuation capability evaluation shall follow the guidelines from the previous slide. If facility has been in operation less than 1 year, it shall be permitted to have conducted a fire drill for each month of its operation.